Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a case at the Supreme Court of Canada that deals with property rights and government expropriation. The case is called Annapolis Group and Halifax Regional Municipality, and it's about something called de facto expropriation. Expropriation is when the government seizes private land for a public purpose, and when they do this, they need to pay the landowner compensation. A de facto expropriation, also known as a constructive or regulatory taking, occurs when title to the land doesn't change, but there is in all other senses an expropriation. For example, when the government places restrictions on the use of the land without formally taking the property. That's what happened in the Annapolis case. In Annapolis, a property developer owned 965 acres of land in Halifax zoned for development. Annapolis says that Halifax has arbitrarily refused their request for development, which has kept the land undeveloped for 15 years, and further, that Halifax has promoted the privately owned Annapolis lands as a public park, including by allowing trail signs to be posted with the Halifax logo. They say Halifax did this in order to get a park for free. Here today to talk about this case and about the law of expropriation are two legal experts. Joanna Barron is Executive Director of the charity I work for, the Canadian Constitution Foundation, who was an intervener in this case, and Malcolm Lavoie is a lawyer and academic who represented the CCF in this case. Thank you both so much for joining me today. Joanna, let me start with you. I outlined some of the facts of this case. Why don't you give us a little bit more background?
Yeah, so the city of Halifax itself was pretty straightforward about their objective here. They posted a publicly accessible Q&A document about the park, and they said that the reason that they didn't zone them as a park was because under planning legislation, they would have been required to actually purchase the subject lands within a one-year timeframe. So this was just an end run around that requirement.
Malcolm, is there anything you want to add to the background of the case that you think is relevant for our discussion today?
No, just that it's a set of facts that's somewhat typical when we're talking about regulatory takings or de facto expropriation. You have a government body that isn't actually taking title, isn't on paper becoming the owner, but nevertheless, they've exercised their regulatory powers to such an extent that the owner is essentially deprived of the benefit of being a property owner. They're not allowed to do anything with the land. And that was essentially the case here. The developers weren't permitted to develop. They weren't permitted essentially to do much of anything with this land.
Even though it was zoned for development. Now, Malcolm, the Canadian Constitution Foundation, the charity Joanna and I work for, we intervened in that case. So what was the role? What's the role of an intervener? Can you explain that? And can you explain who else was participating in the case?
Yeah, certainly. So the two parties to the case were the developer, Annapolis, and Halifax Regional Municipality, the government body that was doing the zoning. When the Supreme Court of Canada hears cases, though, they are open to hearing perspectives from parties that aren't actually, part of the dispute, the appellant and the respondent, but who nevertheless have a perspective to offer on how the law will be developed. Because when the Supreme Court of Canada takes a case, they're taking it because it's an issue of national importance, and that allows them to develop the law in ways that will affect the whole country. And so they're open to hearing other kinds of perspectives. And so the Canadian Constitution Foundation intervened in the case because the court was open to reconsidering the test for de facto expropriation, what exactly the standard is for finding a de facto expropriation. And the Canadian Constitution Foundation's position was that compensation should be offered in a broader range of cases than the Supreme Court of Canada has previously said. There should be stronger protections for property owners. In a previous case, we can get into this, but in a previous case called Vancouver and CPR, the court had set a very high bar for getting compensation for de facto expropriation, arguably, all but eliminating this doctrine from Canadian law. And so the Canadian Constitution Foundation intervened to say, no, where an owner has been fundamentally deprived of ownership, there should be compensation. There were other interveners, mostly on the other side. So I think there were 4 attorneys general representing the governments of 3 provinces and the federal government. They were all in favor of an approach that would make it harder for owners to get compensation. Eco-Justice also intervened. They were on the side of, again, making it harder to get compensation. There were a couple of other, interveners on our side. Yeah.
I'm shocked that the government would take a position as an intervener that it's easier for them to take private property. How unusual. We've got to go to commercial break, but when we come back, we're going to talk about the case that preceded this, the CPR case.
Sure.
Now, the case that we're talking about, Annapolis, involved private property in Halifax that the Halifax government had zoned for development but was not allowing to develop. And it seems to, I think a casual observer would read the facts of that case and say, of course, this was an expropriation. The city was encouraging the public to use the land as a park. They had zoned it for development, and then they kept dragging their feet on allowing development and told people to use it as a park. But in the lower courts, the courts found that didn't amount to de facto expropriation. Joanna, can you explain the concept of de facto expropriation and why the lower court found in that case that it wasn't met?
Yeah, so de facto expropriation is essentially when property has been, for all intents and purposes, deprived of its benefit, but no title has changed. And the current test that Malcolm spoke about in the previous segment is called Canadian Pacific Railway v. Vancouver. It's a 2006 Supreme Court of Canada decision, so it's binding on lower courts throughout the country. And in order to show a de facto expropriation has taken place, the law requires the claimant show two things. First, that the government has acquired a beneficial interest in the property or flowing from it. And second, that all reasonable uses of the property have been removed. So it's an extraordinarily high threshold. And as you say, a casual observer can see that an expropriation has happened here, but it's harder to make out the case that all reasonable uses have been deprived. So this is what happened in this Annapolis case.
And the consequence of not having an expropriation be found is that the city the property owner doesn't get any compensation for having the value of their land taken away. Malcolm, Joanna's outlined the existing test. I want to get your perspective on why you think that test isn't good enough to protect property rights. And maybe you could give us some examples to paint a picture here of where another situation where this test isn't enough, where it clearly an expropriation has happened.
Yeah. So the test, as Joanna outlined, has two prongs. One is about what's been taken away from the owner, all reasonable uses, and the other is what the government has acquired. And our view was that focusing on the specific nature of what the government's acquiring is the wrong way to look at this, that where an owner has been deprived of the essence of ownership, the ability to benefit from their ownership interest, that should be enough. That you shouldn't be asking the question of what exactly the government acquired. And so an example would be the CPR case, the Canadian Pacific Railway case. In that case, you had this railway corridor through the west side of Vancouver, some incredibly valuable land. And the municipality essentially prevented Canadian Pacific Railway from doing anything profitable with that land. And part of the grounds on which they were refused compensation was that, well, the city wasn't actually acquiring anything. All the city was doing was preventing certain uses. Emphasis was placed on the fact that they were still allowed to run a railway on that land. However, it was acknowledged by the court in that case that running a railway on that land was no longer a profitable use. And so CPR had no profitable uses. And part of the reason that they were being deprived of, or they weren't entitled to any compensation for that restriction, was that the government wasn't actually becoming the owner, wasn't taking any so-called beneficial interest, even though, of course, the city derived a kind of benefit from it. It got to preserve the corridor in place in case they wanted to use it for future purposes. And so that, I think CPR itself is a good example where you see that focus on what the government's getting is misguided. That, in our view, the focus should be on what the owner's been deprived of.
So the Canadian Constitution Foundation has proposed a new test for de facto expropriation. We've got about a minute in this segment. Can you briefly outline what you're proposing the new test should be?
Well, there's essentially two forms of conduct. One would be where the government deprives an owner of their right to exclusive possession. So if the government occupies a land or physically invades it or perhaps destroys it, we think that should give rise to a right to compensation. Alternatively, where the government's just restricting the owner's use, the question should be, has the owner been deprived of all reasonable uses? But that test should be applied in a way that focuses largely on economic value. If you want to know whether there are reasonable uses remaining, ask whether any of those uses have positive economic value. If the uses remaining are just notional, if there's something that no one on the market would be willing to pay money for, then that's a signal that the uses aren't reasonable. And so our test focused more on what economic value remained to the owner.
We've got to go to commercial break, but we'll continue this conversation when we get back. Welcome back to Canadian Justice, where we're discussing government expropriation and property rights. Now, Joanna, many Canadians may be surprised to learn that we don't have constitutionally protected property rights in this country, especially when it's well known that our American neighbors do have constitutionally protected property rights. So what can you tell me about why we don't have those protections in Canada?
Well, there are common law protections of property rights. The Canadian Bill of Rights, which predated the Charter, protects property. And the historical record indicates that it's not for want of trying. The Liberal government from the late 60s intended on entrenching property rights in the Constitution, pardon me. It was the policy of Pierre Elliott Trudeau when he proposed the Charter in 1968 as Justice Minister, and then again when he was Prime Minister, when the Charter was negotiated. And ultimately, it didn't make it in. And as far as I know, the academic position is that this is both due to historical circumstances, legal misapprehensions, and just the general climate of Charter negotiations didn't make it in.
Malcolm, anything you want to add there about the history of Canada's Constitution and why property rights aren't enshrined in our Constitution? And would giving them constitutional protection give Canadians better property protections?
Yeah. So I'll say as Joanna alluded to, property rights are protected by our sort of common law constitutional tradition. This idea that presumptively owners have protections, and it's only if the legislature or parliament speaks clearly that those property rights can be taken away. But the more specific question of why they weren't entrenched in the Charter is an interesting one. The leading work on this is by Dwight Newman and Laurel Binion. They have an article where they go through the historical record, and they show that it was quite a sort of set of contingent circumstances that could have been otherwise. Certain parties, the NDP parliamentary caucus and a couple of provinces were simply more effective than others, including the Conservative caucus at the time, in advancing their views. But as Joanna mentioned, Pierre Trudeau's initial drafts supported having property rights in the Charter. It was seen as a fundamental part of our constitutional tradition. And it was just a set of sort of contingent circumstances and political machinations that resulted in it being left out. It ought to have been there, and so that does have consequences. It has consequences, of course, in the sense that you can't challenge clear legislation that deprives someone of property rights because there isn't that entrenched constitutional protection. But some have argued that the omission of property rights from the Charter has also had a symbolic value, in the sense that people have come to regard people, including judges on our courts, have come to regard property rights as somehow lesser rights because they weren't included in the Charter. And that's contrary to, I think, the intent of the Charter. Section 26 of the Charter says the inclusion of certain rights in the Charter shouldn't be taken to detract from other rights that have existed in Canadian law. And I think our courts have forgotten that. And part of what we've seen with de facto expropriation, this erosion of protections for property rights at common law, is a product of that, is a product of this misapprehension that property rights simply aren't important.
Joanna, what can you tell me about de facto expropriation in other countries? I mean, are there better protections against de facto expropriation or regulatory takings in countries like, for example, the United States?
Yeah, so of course the US does have constitutionally protected property rights, but actually losses have to be pretty severely high in many US jurisdictions before harm can be claimed. The strongest countries are actually Poland, Germany, Israel, the Netherlands, Sweden. For example, in Poland, if you're a landowner, you have the right to demand that land that is taken or adopted for public use be compensated, even if the loss in value is 1%. You have the right to that 1% compensation.
Malcolm, where does the right to compensation for expropriation fit into property rights? Is this an inherent right that we have? Is it a common law right?
Mhm.
Is it available only when the statute says so? Where does it come from? We've got about a minute.
Yeah, there's been some back and forth on this issue in Canadian law. The CCF's position, and I think the better view, is that owners have a common law right to compensation when the government does something that amounts to expropriation. It's a common law right. So if you have a clear legislative statement in a bill passed by the legislature or parliament, that can take the right to compensation away. But in the absence of a clear statement like that from the legislature, there's a presumptive common law right inherent in property ownership that entitles one to compensation in the common law courts. And so our view, and I think the better view, is that it is a common law right.
We've got to go to commercial break, but we will continue this conversation when we come back. Welcome back to Canadian Justice, where we're discussing government expropriation and property rights. Now, Malcolm, if the Supreme Court in this Annapolis case broadens the test for de facto expropriation, making it easier to claim than it currently is, what will this mean for cities and other levels of government in the future? Are they going to need to conduct themselves differently?
Well, I think in the vast majority of good faith zoning cases, this doctrine won't apply. If you're talking about simply restricting uses while leaving an owner with a meaningful set of options, that's not a de facto expropriation. If there's a broadening of the test, if you sort of take away or diminish that beneficial interest requirement, if you open up the reasonable use standard, it does mean that where a municipality or some other government body regulates to such a degree that there are no reasonable uses left, in our view, that should be assessed largely by whether there's economic value remaining, then that means there's an entitlement to compensation. It doesn't mean the government body can't do it. It just means that if they're going to fundamentally deprive an owner of the benefits of their property rights, they should pay for it. Either conduct a full formal expropriation with the entitlement to compensation, or pay the compensation that's applicable at common law. So all it means is that in these cases of extreme impacts on an owner's rights, the government body will have to pay for it.
So just very briefly, Malcolm, how common is it for governments to engage in de facto expropriations? Is this something that is rare in Canada?
It's sort of hard to assess that, in part because the CPR test was so restrictive that property owners really stopped bringing claims because the claims seemed doomed from the outset on that really high bar the Supreme Court set in 2006 in the CPR case. I will say I don't think this is an everyday occurrence. I think that property rights are still regarded as generally important, not just by courts and sort of bodies like the CCF, but more generally. I think municipalities try to avoid having impacts that are this extreme on parties. But it does happen, and there have been cases brought, and there are other cases where parties don't bother litigating, where an owner has been fundamentally deprived of the rights of ownership. And so I think this does happen, and it's important to have this protection in place.
Well, it'll be interesting to see if the test changed, what does happen. Joanna, this is one of a number of cases that the CCF has done about property rights in Canada. What are some of the other cases that you've done on this particular topic?
Yeah, so the CCF represented the Rileys, which were a husband and wife that owned properties which they rented out at below market rates to help people who were impoverished. And the government first took control and allowed their properties to fall into disrepair, then permanently seized them on the grounds that some of the tenants' rents had been paid with the proceeds of crime, even though there was no evidence of that. The state just merely assumed that and seized these, very valuable properties. And then more recently, just last year, the CCF intervened at the Ontario Court of Appeal in a case called Norwood Estate. And this was a matter where the court approved a forced settlement between the estate of a deceased and his mother, who alleged to have a claim to the portion of the home. And this was before any determination was made about whether the home constituted proceeds of crime.
So those are cases that relate to a different area of law called civil forfeiture, which is different from expropriation, but certainly has a really significant impact on property rights. And it's a fascinating area of law. Both of these are really fascinating. Joanna Barron from the Canadian Constitution Foundation, Malcolm Lavoie from Miller Thompson. I want to thank you both so much for coming on today. This was a really fascinating discussion about an area of law that I really love, and I hope our viewers enjoyed it.
Thank you.
Thank you.
We've heard today about government expropriation, including de facto expropriation, where the government takes land but doesn't take title to the land. The right to own property lies at the core of liberal democracy. Protections for property can be traced back to the Magna Carta and the English Bill of Rights from 1689, and they were affirmed in the 1948 United Nations Declaration of Human Rights, to which Canada is a signatory. But in Canada, when it comes to de facto expropriation, our property rights are not well protected at all. While we wait for the decision from the Supreme Court, ask yourself how you would feel if the government took your land away from you. How can we better protect our property from government overreach? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.